officers.
Identified foreign vessel at Sabina Shoal. This is Philippine Coast Guard. PRP Cabra MRRV 4409. You are within Philippine Exclusive Economic Zone.
We are Group 2, and we will be discussing the arbitral ruling of the South China Sea dispute. Here are the members of our group. For the outline of our presentation, John and I will be discussing the NineDash Line and China's claim to historic rights in the South China Sea. Meanwhile, Nefertari shall be discussing the status of certain maritime features in the South China Sea. And finally, Mr. Xian shall tackle the legality of Chinese activities in the South China Sea.
Hello everyone! Welcome to the arbitral ruling on the West Philippine Sea conflicts. The conflict over the South China Sea is not just one of military might and political clout, but also one of legal strategies. The Philippines specifically has sought to counter Chinese moves with a turn to international adjudication and with significant success. Now let us hear from Ron and John regarding what they found out about the NineDash Line and the alleged Chinese historic rights.
Here, I will be discussing submission number 1 of the arbitral ruling on the NineDash Line and China's claim to historic rights in the maritime areas of the South China Sea. Submission 1 states that China's maritime entitlements in the South China Sea, like those of the Philippines, may not extend beyond those expressly permitted by the United Nations Convention of the Law of the Sea, UNCLOS, or the Convention. Here is the Philippines' position on the matter. It has argued that any rights that China may have had in the maritime areas of the South China Sea beyond those provided for in the Convention were extinguished by China's accession to the Convention. China, however, had a different position. Its position on its jurisdiction concerning its entitlements and maritime zones, however, were claimed to be supported by its various declarations and legislations that they have made. Here are the ones that have purported to support their claims on their jurisdiction. A decree that was issued that defined a territorial sea of 3 nautical miles, a declaration of China's territorial sea, a law whose provisions would state and define its jurisdiction in the South China Sea, a declaration which set out certain coordinates for the baseline from which its territorial sea would be measured, a declaration of an exclusive economic zone in conjunction with its ratification of the Convention, a law on the EEZ and the continental shelf that described the extent of the former and the latter, and Article 14 of the aforementioned law, which provided the rights of the People's Republic of China shall not be affected by the provision of this law. China stated that the Chinese government has given publicity several times the geographical scope of China's Nansha Islands and the names of its components. China's Nansha Islands are therefore clearly defined. In addition, under the relevant provisions of the 1982 United Nations Convention on the Law of the Sea, as well as the laws mentioned above, China has indisputable sovereignty over the South China Sea Islands and its adjacent waters. China's sovereignty and relevant rights in the South China Sea are upheld by successive Chinese governments, reaffirmed by China's domestic laws on many occasions, and protected under international law, including the UNCLOS. The issue at hand here, based on the submission number 1, is whether or not the Convention, and in particular its rules for the exclusive economic zone and continental shelf, allows for the preservation of rights to living and non-living resources that are at variance with the provisions of the Convention, and which may have been established prior to the Convention's entry into force by agreement or unilateral act. Here are the Tribunal's considerations on the matter. They have stated that no article of the Convention expressly provides for or permits the continued existence of historic rights to the living or non-living resources of the exclusive economic zone. Similarly, nothing in the Convention expressly provides for or permits a state to maintain historic rights over the living and non-living resources of the continental shelf, the high seas, or the area. The question for the Tribunal is therefore whether the convention nevertheless intended the continued operation of such historic rights, such that China's claims should be considered not incompatible with the convention. As a matter of the text alone, the Tribunal considers that the Convention is clear in according sovereign rights to the living and non-living resources of the EEZ to the coastal state alone. The notion of sovereign rights over living and non-living resources are generally incompatible with another state having historic rights to the same resources, in particular if such historic rights are considered exclusive, as China's claim to historic rights appears to be. The Tribunal considers that, as a matter of ordinary interpretation, the express inclusion of an article setting out the rights of other states and attention given to the rights of other states in the allocation of any excess catch preclude the possibility that the convention intended for other states to have rights in the exclusive economic zone in excess of those specified. After taking into account all the aforementioned considerations, the Tribunal concluded that, for the reasons set out above, as between the Philippines and China, the Convention defines the scope of maritime entitlements in the South China Sea, which may not extend beyond the limits imposed therein.
Thank you, Ron, and hello, everyone. In the same context, in the arbitral ruling on the NineDash Line, the Philippines also submits China's claim to sovereign rights jurisdiction and to historic rights with respect to the maritime areas of the South China Sea encompassed by the NineDash Line are contrary to the Convention and without lawful effect to the extent that they exceed the geographic and substantive limits of China's maritime entitlement expressly permitted by UNCLOS. The Philippines' position on China's claim to historic rights is in two folds. First, the international law did not historically permit the type of expansive claim advanced by China. Second, on the basis of historical record, China cannot meet the criteria for having established historic rights within the NineDash Line. UNCLOS states that the sea is subject to two principles. First, the principle of the freedom of the seas, and the principle of control over limited area by the immediate adjacent coastal state. The tribunal ruled that China's claim is inconsistent with both principles. Thusly, the Convention leaves no room for assertion of rights to control activities beyond the limits fixed in the Convention in derogation of the sovereign rights of other coastal states or the rights and freedoms of all states. The Philippines' contention states that China's historical claims to the features of the South China Sea did not until 2009 include a claim to the waters beyond the territorial seas. Although China did make clear in May 2009 that it claims historic rights in the maritime areas within the NineDash Line, the Philippines admits that this was promptly objected by the other littoral states of the South China Sea. As such, China has no historic rights within the NineDash Line. China's contention, however, states that sovereignty and relevant rights in the South China Sea were formed throughout the long course of history. The dotted line came into existence much earlier than UNCLOS. Thus, the tribunal does not have jurisdiction over the China's dotted line. The issue here is that whether China has established rights and jurisdiction over living and non-living resources in the waters of the South China Sea. If so, would such establishment of rights and jurisdiction be compatible with the Convention? The Tribunal considers Paragraph 3 and Paragraph 4 of Article 311 of the Convention, which permits the states to agree between them to modify the operation of the Convention, provided that such agreements are notified to other state parties and does not affect the rights of other states and are in keeping with the object and purpose of the Convention. However, the Tribunal doesn't consider it necessary here to address in general whether and under which conditions the Convention may be modified. A unilateral act alone is not sufficient. Here, there is no basis for such claim. The arbitral ruling on submission number 2 states that no article of the Convention expressly provides for or permits the continued existence of historic rights to the living or non-living resources of the exclusive economic zone. Similarly, nothing in the Convention expressly provides for or permits a state to maintain historic rights over the living, and non-living resources of the continental shelf, the high seas, and the area. To conclude, the Nine-Dash Line is contrary to the convention without lawful effect to the extent that they exceed geographic and substantive limits of China's maritime entitlements under the convention. Also, the convention supersedes any historic rights or other sovereign rights or jurisdiction in excess of the limits imposed therein.
Thank you, Ron and John. Based on those submissions, the tribunal concluded that China's claims were contrary to UNCLOS and exceeded the geographic limits imposed by it. At this juncture, let us hear from Terry about the status of maritime features.
This talks about the status of features in the South China Sea, mainly focus on the submissions 3 to 7 by Philippine representative. So, the primary basis of the ruling of this arbitration is the 1982 United Nations Convention on the Law of the Sea, which is also known as Convention or UNCLOS, that both countries are uh, parties to the convention and ratified it as the Constitution of the Seas. So, Article 121 of the Regime Islands provides that an island is naturally formed area of land surrounded by waters which is above water at high tide, except as provided for in paragraph 3, the territorial sea, the contiguous zone, the exclusive economic zone, and the continental shelf of an island are determined in accordance with the provisions of this convention applicable to the to other land territory. So it is also discussed that the rocks which cannot sustain human habitation or economic life of their own shall have no exclusive economic zone or continental shelf. So, I'm sorry. So there are five issues submitted for um, relief in this convention that tackles with the features in the South China Sea. So it first, the Scarborough Shoal generates um, no exclusive entitlement. No entitlement of exclusive economic zone or continental shelf, the entitlement of a territorial sea, exclusive economic zone, or continental shelf as features that are capable of appropriation upon occupation in Mischief Reef, Second Thomas Shoal, and Subi Reef as low tide elevations, Mischief Reef and Second Thomas Shoal as part of the exclusive economic zone of the Philippines, Given and McKinnon Reef as low tide elevation that do not generate entitlement to territorial sea, exclusive economic zone, and continental shelf to be used as a baseline from which the breadth of territorial sea of Namit and Sincoe is measured. And then Johnson Reef, Quarteron Reef, and uh, Ferry Reef have no entitlement of exclusive economic zone and continental shelf, just like in submission 3. So here are the names, English names of the reefs or shoal in their respective um, Chinese name and Filipino names. So the arbitration found that the Scarborough Shoal, Given Reef, McKinnon Reef, Johnson Reef, Quarteron Reef, and Ferry Cross Reef are all land surrounded by water, which are all high tide feature within the provision in Article 121, Paragraph 1, which gives them the entitlement of territorial waters, exclusive economic zone, and continental shelf. However, it is also said that the features that the said features are uninhabitable, which is described in Article 121, Paragraph 3, as a rock which are not entitled of exclusive economic zone and continental shelf. Hence, the submission 3 and 7 of the Philippines is affirmed that Scarborough Shoal, Gaven Reef, McKinnon Reef, Johnson Reef, Quarteron Reef, and Ferry Cross Reef cannot generate entitlement for exclusive economic zone and continental shelf. I'm sorry. So the maritime zone of low tide elevations such as Mischief Reef, Second Thomas Shoal, Subir Reef, and Gaven Reef and McKinnon Reef are governed by Article 13 of the Convention. It is provided in Article 13, Paragraph 2 that the low tide elevations are not entitled of maritime zones and are not capable of appropriations or occupation. Therefore, the low tide elevations are not entitled of territorial sea, exclusive economic zone, and continental shelf. So the China cannot appropriate the Scarborough Shoal, Gaven Reef, McKinnon Reef, Johnson Reef, Quarteron Reef, and Ferry Cross Reef as their territory. This, according to Article 13, Paragraph 1, low water line of a low tide elevation can be used as a baseline in measuring breadth of territorial sea, even if cannot generate maritime entitlement, which affirms the submission 5 of the Philippines. So due to the findings from the previous submissions, the arbitration concludes that there are no high tide features claimed by China in Spratly Islands that can generate territorial waters, exclusive economic zone, and continental shelf that would overlap the entitlements of the Philippines in the area of Mischief Reef and Second Thomas Shoal. Therefore, the Mischief Reef and Second Thomas Shoal, which also known as Panganiban Reef and Ayungin Shoal, are both within the exclusive economic zone and continental shelf of the Philippines. So to finalize, all features in questions in the submission 3 to 7 have no maritime entitlement. The Philippines have no sovereignty in the Spratly Islands and only have sovereign rights with regard to the exclusive economic zone and continental shelf in Mischief Reef and Second Thomas Shoal, which is also known as the Panganiban Reef and Ayungin Shoal in the Philippines. So that's it.
Lastly, let us listen to Ram with regard to the Chinese activities in the South China Sea.
I will now discuss the final point of this three-part report. In particular, China's violation of the UNCLOS with regards to the Republic of the Philippines versus the People's Republic of China's dispute on the West Philippine Sea, where its ruling was promulgated on July 12, 2016. This report will focus on Chinese activities in the South China Sea. Submissions number 8 to 13. These includes, number 1, the alleged failure to prevent Chinese nationals from exploiting the Philippines' living resources. 2, China's action in respect of traditional fishing at the Scarborough Shoal. 3, alleged failure to protect and preserve the marine environment. 4, operation of law enforcement vessels in a dangerous manner. And 5, aggravation or extension of the dispute between parties. The first charge is the alleged failure to prevent Chinese nationals from exploiting the Philippines' living resources. The Philippines here contends that China has unlawfully failed to prevent its nationals and vessels from exploiting the living resources in the EEZ of the Philippines. It that China's violated the obligations of Article 56 of UNCLOS, and China has established control over the areas of South China Sea. China here gave no response as of the allegations of the Philippines, in which the tribunal ruled that China has breached the obligations set under Article 58, Paragraph 3 of UNCLOS. Article 53 states the rights and duties of other states in the exclusive economic zone, where Paragraph 3, in exercising their rights and performing their duties under this convention in the exclusive economic zone, states shall have due regard to the rights and duties of the coastal state and shall comply with the laws and regulations adopted by the coastal state in accordance with the provisions of this convention and other rules of international law insofar as they are not incompatible with this part. The second charge of the Philippines against China is China's actions in respect of traditional fishing at the Scarborough Shoal. The Philippines contends that China has violated Articles 279 and 300 of the convention, and the Philippines seeks to distinguish the submissions regarding historic fishing and historic rights as claimed by China. China, like the Philippines, claims sovereignty over the Scarborough Shoal and asserts that the waters constitute traditional fishing grounds for Chinese fishermen. The tribunal here ruled that China has, through the operations of its official vessels at Scarborough Shoal, unlawfully prevented Filipino fishermen from engaging in traditional fishing at Scarborough Shoal. It records that this decision is entirely without prejudice to the question of sovereignty of the Scarborough Shoal. Third is the alleged failure to protect and preserve the marine environment. The Philippines contends that it submits that China has damaged the diverse and fragile ecosystems of the South China Sea. Its building of its activities do not fall within the military activities under Article 298, Paragraph 1, Subsection B, and it notes that they do not invoke military exception and that China has repeatedly characterized their building of their structures as for civilian purposes. China here has not directly stated its position with regards to the allegations as presented with number 11 and 12 subsection B of the Philippines submission. China indeed has breached obligations under Article 192 and 194, Paragraph 5 of the Convention as ruled by the Hague Tribunal. Article 192 states that the states have the obligation to protect and preserve marine environment. And 194, Paragraph 1 and Paragraph 5 talks about the measures here to prevent, reduce, and control pollution of the marine environment. States shall take steps in order to prevent, reduce, and control pollution of marine environment from any source, and that the measures taken in accordance with this part shall include those necessary to protect and preserve rare or fragile ecosystems, and as well as habitat of depleted and threatened and endangered species or other forms of marine life. Next is the operation of law enforcement vessels in a dangerous manner. Our country here contends that China has breached the obligations relating to navigations under Article 4, the duties of flag states, and Article 21, the regime of islands of this convention. China here has made no statements as to specific matters raised in the Philippine submission of number 13 concerning the incidents in the vicinity of Scarborough Shoal, and it has made statements, however, concerning the presence of Chinese vessels at Scarborough Shoal, both generally and in response to Philippine diplomatic notes considering these incidents. The tribunal here finds that China has, by virtue of conduct of Chinese law enforcement vessels in the vicinity of the Scarborough Shoal, created a serious risk of collision and danger to Philippine vessels and personnel. Next is the aggravation or extension of dispute between the parties. The Philippines here contends that the tribunal has jurisdiction to consider its submissions number 14 and argues that Articles 297 and 298 of the Convention do not exclude the tribunal's jurisdiction consider this submission. To consider this submission. And China, however, states the importance of good faith and the duties incumbent on state parties pursuant to the convention, and has said that the Philippines has violated the principle of good faith. Here, it declares that China has breached the obligations pursuant to Articles 279, 296, and 300 of UNCLOS, as well as pursuant to general international law to abstain from any measure capable of exercising a prejudicial effect in regard to the execution of the decisions to be given, and in general, not to allow any step of any kind to be taken which might aggravate or extend the dispute during such time as dispute resolutions proceedings were ongoing. They cited Article 279, which states that parties shall settle any dispute between them concerning the interpretation or application of this convention by peaceful means in accordance with Article 2, Paragraph 3 of the Charter of the UN, and to this end shall seek a solution by the means indicated in Articles 33, Paragraph 1 of the Charter. Articles 2 and 33 of the Charter of United Nations talk about the duties of country whenever there are conflicts, to always choose to always be pacifistic and settle it in an amicable matter. Article 2 of the United Nations states here, and Article 3 of the Pacific Settlements of the Disputes. Article 296 here, the finality and binding of the force of decisions. Any decision rendered by a court or tribunal having jurisdiction under this section shall be final and shall be complied with by all the parties to the dispute, and any such decision shall have no binding force except between the parties and in respect of that particular dispute. Article 33 states, to counter China's claim of Philippines' absence of good faith, state parties shall fulfill in good faith the obligations assumed under this convention and shall exercise the rights, jurisdiction, and freedoms recognized in this convention in a manner which would not constitute an abuse of right.
Thank you so much, Ram, for that summative report regarding those activities in the South China Sea. Now let's proceed to the one question, which is how was the Permanent Court of Arbitration involved? With this, we are reminded that the root of the disputes presented by the Philippines in this arbitration lies not in any intention on the part of China or the Philippines to infringe on the legal rights of the other, but rather it has been apparent throughout these proceedings in fundamentally different understandings of their respective rights under the Convention in the waters of the South China Sea. In such circumstances, the purpose of dispute resolution proceedings is to clarify the parties' respective rights and obligations and thereby to facilitate their future relations in accordance with the general obligations of good faith that both governments unequivocally recognize.
Ladies and gentlemen, if you've watched until the end of the video, this concludes our discussion on the ruling of the people of the Republic of the Philippines versus the People's Republic of China arbitration ruling on the West Philippine Sea, promulgated on July 12, 2016. We hope that this video, in any way, shape, or form, may help you and increase your awareness and knowledge regarding the West Philippine Sea dispute, and continue your further studies. It will help you continue for your studies in the Constitution and the territory of the Philippines.